Welcome to the second presentation relating to Chapter 3. Let's go ahead and get started. This chapter covers the American legal system and the alternative dispute resolution. But this particular portion of the presentation will be about ADR, alternative dispute resolution. So I'm going to advance in the video to the very end of the chapter. And so we've been talking to this point in the first lecture. We've been talking about how the court system works. And the court system is awesome and amazing and really, really important, obviously. But actually, it's not the way we usually resolve disputes in our society. About 97% of the time, we resolve disputes through alternative dispute resolution, wherein people decide not to use the court system. That seems kind of strange. Why do we have this fancy-dancy court system and then we opt not to use it? Well, there's lots of reasons. Here are four that are oftentimes cited. First, it's often faster. Depending upon whether you're in the federal system or the state system, it'll take from the time that a lawsuit is filed until you go to trial and get that resolved, it'll take anywhere from 1 to 3 years. And it will almost never happen quicker than a year. So it's going to be a significant period of time. It's also going to be quite expensive. Major corporations pretty routinely budget $100,000 for virtually any lawsuit that is not obviously frivolous. Even ones that they feel they will ultimately be able to dismiss, they still have to respond to discovery. They still have to hire attorneys. There is a cost, and those costs are eventually borne by the consumers and by the shareholders because there are fewer profits and there are more costs associated with business. So we as a society bear those costs. So if we can figure out a way to resolve the disputes in a faster and a cheaper way, it's a win-win. Another thing that's important is that litigation is inherently uncertain. If both sides knew who was going to win, there would be no reason to have a trial, right? I mean, the only reason you ever have a trial is because one party thinks that they are more likely to win than the other party thinks. If both parties knew exactly what was going to happen, then we could just forego the expense. There's uncertainty. We don't know who's going to be on the jury. We don't know their names, but even if we do know their names somehow, we don't know very much about those people, about their life experiences. Even when we do know things like demographic information, their race, their religion, their age, their profession, their socioeconomic level, those types of things. That gives you some information about a person, but we're not the sum total of those characteristics. There's lots of things about each one of us individually that makes us special and different from maybe the groups that we associate with. So there's a lot of uncertainty when we go to a jury trial. But when you use ADR, at least many of the tools that we'll talk about, that uncertainty is removed. Many of us, I would say probably most of us, are risk averse. It's why we don't go to a casino and bet the house, even if there was no cut for the house. In other words, the gaming establishment was not making any profit, and so there was, if we rolled the dice and we got tails, we won $1 million. If we got heads, we had to pay $1 million. Most of us would still not want to participate in that game. We are more concerned about the downside than we think the upside is going to be good for us. And so when you are concerned more about the downside than the possible upside, that makes you more and more interested in avoiding that uncertainty. And of course, to live with the uncertainty, especially over an extended period of time, is very, very stressful. As somebody who's litigated cases, I can tell you that the witnesses and the parties really, really are affected. I've had many people in business litigation tell me I can't sleep at night. It's all I think about. It impacts their productivity at work. It impacts the quality of their life. There's all kinds of repercussions, and this can go on for months and months and months. So there's all kinds of psychic harm, emotional harm that is being done to folks as well. Another concern sometimes can be the establishment of a precedent. We saw this in the tobacco litigation. this is back, I guess, in the 80s, wherein a lot of tobacco companies were being sued, in many cases by states' attorneys general, because of the cost of Medicare and Medicaid that the state has had to experience. And then there were other cases involving unusual fact patterns where people were suing and the cases hadn't been dismissed. The cases that were really concerning to the tobacco industry, in many cases they wanted to settle those cases because they either didn't want to create a legal precedent, or more often they didn't want to create a precedent in the public sphere that was going to be in the paper that might affect future juries or might affect how their product was viewed in the larger society, both by smokers and non-smokers. And of course, non-smokers can be involved in regulating the industry. So you can be concerned about social precedents as well as legal precedents. Another advantage to ADR is that it's confidential, and this can be really, really important. I did labor and employment litigation, and I can tell you that one of the greatest concerns, especially when it is a high-profile or class action case, is the concern that the employer can have that this will be disruptive of the business. If details of it become public, perhaps there will be copycat litigation or other concerns. So confidentiality can sometimes be a very important driving force. A factor that sometimes people don't consider as often as I think they should is that sometimes ADR is used to reduce the amount of adversarialness. Obviously, litigation is inherently adversarial. It's almost impossible, in my experience, to go through litigation and remain, fairly friendly with the other side. There's just too much drama, too much emotion associated with it, even when the matter is relatively small, relatively unemotional. Just it's hard to separate those emotions from going forward in that business situation. Imagine for a second that you are a supplier for Walmart. You supply many products. We'll say you're Toro, the lawnmower manufacturer, and you have several different contracts with Walmart. You sell edgers, you sell leaf blowers, you sell lawnmowers, you sell all kinds of different models of these things. You have several different contracts. It's profitable for your business, it's profitable for Walmart. Most likely these contracts provide for an arbitration provision. We'll talk more about that later. But let's assume that for whatever reason, one of these contracts did not provide for that particular clause, and a dispute arose about the matter, and let's say that Walmart decided to sue Toro. Now, Walmart has all these other contracts with Toro, and it's making money based upon them, so it doesn't want to end the relationship with Toro, but it does want to protect its rights with respect to this particular dispute. So it files a lawsuit. The case proceeds through discovery. There's all of the expense and the hassle and the emotionality of that. Inevitably, people think that the other side's lying or exaggerating or doing something unfair or unethical. Those issues just are always going to come up. And so at the end of the case, maybe Walmart wins, maybe Toro wins, but either way, the relationship is kind of damaged and will probably remain damaged for a while. And Walmart might start looking at other lawnmower companies, to see if maybe there might be a better fit out there. And of course, Toro doesn't want to do that. So Toro is going to definitely want to have an arbitration clause. Now, I don't mean to say that arbitration is some kind of panacea that nobody ever gets their feelings hurt in arbitration. They certainly do. It has the same risks that litigation does. They're just reduced risk. There's less emotion, there's less time, there's less depositions, there's less procedural jockeying that happens, and so it can result in a greater ability to maintain the relationship outside of that context. So that can be another factor. A fifth factor, which is I mentioned up here, is that courts favor alternative dispute resolution. Courts like it for a lot of reasons. One of the big reasons is that it takes cases off their docket. They have less work to do. A second reason is that it causes their dockets to move faster. The cases that can't settle can get to a jury quicker. Also, it means fewer jurors have to be inconvenienced by service, and that's a win for everyone. So there's lots of reasons why the courts favor ADR, but they favor it also for the reasons that we specified below. So courts are going to encourage it, and sometimes they're going to require it. The courts can't require that parties actually settle suits through ADR, but they can require that they go through that process, and we'll talk about many of the alternative dispute resolution tools that we have. But at the end of the day, just making sure we're clear on our terms, is alternative dispute resolution. The alternative is to litigation. And as I said before, it's what we do 97% of the time. So you might even say that litigation is the alternative dispute resolution tack, and that ADR is the main way that we resolve disputes. Let's go on and let's look at some of those particular tools. ADR is only limited by the imagination of the parties involved. Here are a few popular, varying degrees of popularity, formats for resolving disputes. The top three are the ones that I'm going to focus the most attention on. They're the most common, and it's certainly the ones that are most important for you to know about as a business professional. The first one, negotiation, is something that doesn't even require an attorney. In this situation, people sit down together and try to solve the problem. It may be a discussion about settling the lawsuit or paying a certain sum of money, or it can be about an apology. There's lots of different approaches. We all negotiate all the time. I mean, if you want to eat Chinese and your friend wants to eat Mexican, there's a give and take. Well, we ate Mexican last time. Why don't we eat Chinese this time? Or, well, how about if we eat Italian instead? There's a give and take that happens where people float ideas and explore different possibilities. Negotiation is inherently significantly more flexible than you'd find in a court system. Typically, this isn't 100% true, but typically the court is only going to be able to award money. It's not going to be able to come up with creative solutions like, let's have Italian instead of Mexican or Chinese, or offering an apology. What if I were to apologize? How would that make you feel? Or what if we were to change how we do things going forward? Those type of solutions are not usually within the things that the court can do, and so it gives the parties more power to handle the resolution. And it's also very empowering. When you look at these other processes, once you enter the litigation system, in some sense, the parties lose control over it. It's the judge, it's the jury, it's the process that takes control. But in negotiation, the parties reclaim control. They decide whether they're going to settle. They decide how they're going to settle. They decide what that's going to look like. And if a party doesn't want to settle, guess what? They can't be required to settle through negotiation. Mediation is the next tool. It's a little bit more involved than negotiation, although not much. It's very similar to negotiation, but there is a third party involved. When I say third party, I mean a disinterested party, a party who isn't on the side of the plaintiff and isn't on the side of the defendant. Oftentimes, this person is going to be a legal a professional, could be an attorney, could be a paralegal. It doesn't have to be, though. Sometimes the mediator is a subject matter expert. Imagine that this is a situation in which a bridge has failed. Well, you might want to have a civil engineer be the mediator, because he or she's going to be able to understand the physics and the materials science aspects of the case. And so he or she will be in a position to kind of evaluate the strengths of the arguments. In a mediation, the mediator does not have any authority to decide the case or to force the parties to settle. But hopefully he or she brings to the table credibility with both sides. Both sides will know that this person isn't on either side, that this person is just coming to this situation to resolve it. He or she is typically paid a certain amount of money to mediate a case on a certain day, and he wasn't involved in the case the day before. She isn't going to be involved in the case the day after. And so he or she listens to both sides and shows each side the weaknesses of their case, the things that they ought to be aware of are weaknesses. And sometimes hearing this from a disinterested party the litigants can believe it maybe for the first time, and so there can be a coming together of expectations and understanding of the facts, and people can be a little bit more open to solving the problems. Now, I've done a lot of negotiations and mediations over the course of my career, and it's relatively few times that I've been able to settle a case through mediation. But I will tell you, even though I rarely settled a case actually at the mediation, many times that was an important step in getting us to an eventual settlement. So we might do some initial negotiation, then go to the mediation, and then go back to negotiation. Another advantage to mediation in my experience is that many times mediation is court ordered. The court is telling the folks, okay, you have to go and meet. And that can be helpful because one of the problems with settling cases, and this is going to sound odd, but it's true, is that sometimes both sides want to talk about settling it, but no one wants to be the first to talk. Because when you're the first to mention it, the perception is that you are now in a less powerful position. After all, oh, you want to settle. You must think your case is bad. We think our case is great. Well, we'll entertain what you have to say, but you should know that we really aren't that interested in settling. You can see how being the first to mention it can cause your position to seem weaker. So many times in these cases, both parties want to talk settlement, but neither wants to be the first. So the judge can play that role. The judge can say, okay, you have to go to mediation. And then both sides can say, well, we don't think we need it. We want to go to trial. But if you insist, Your Honor, we'll do what we have to do. And yet they're both privately thinking, oh, yes, this is great. Yay, yay. So that's an advantage to mediation. I would say most mediations are done because the court or some government agency has either suggested it or required it. But that's not a requirement. Some parties actually choose on their own to go into mediation. Okay, the third one, and this is the first two, you're almost always going to have at some point in litigation. Arbitration, the third choice, is less frequent. It's more common than the other tools that we'll talk about in a second. But it is an important tool. This is especially important in business-to-business type situations. So arbitration, this is when a case is not litigated through the court system, but it's actually removed through the court system and put through an arbitration process. Instead of having a judge and a jury, you have an arbitrator who decides the case. He or she acts as a judge or jury. Sometimes there's a panel of arbitrators, so it may not just be one arbitrator. And then the case proceeds in some respects in a fairly similar way than it would if it were in the litigation system. There will likely be some motions filed. There will likely be some discovery. There will be a trial. People will be under oath. Documents can be subpoenaed. So there's, in many senses, a similar process, although usually there's a lot less discovery. The trial date comes a lot sooner because the arbitrator is actually employed by the parties. Usually, you don't have to wait for a trial docket to clear up, and you don't have to wait for a jury panel. So usually arbitration cases can go from beginning to end in about 6 months, so significantly quicker. The result of an arbitration is an award. That's the term that we have for that. So how do you end up in arbitration? Well, the first thing to keep in mind is that the judge in a civil case can't require parties to arbitrate. So if there is no contract and one party or both parties don't want to arbitrate, it's not going into arbitration. There's two ways that you can have a contract for arbitration. One is pre-dispute. This comes up in business-to-business contracts and also in employment contracts and in other situations, but we'll just talk about those as maybe the two big ones that we see a lot of. So imagine that I'm going to work for a big corporation. In fact, about a third of big corporations do require a significant portion of their workforce to sign employment arbitration agreements. And they are generally enforceable in most states. In Texas, they are quite enforceable. There are some jurisdictions that they are not necessarily enforceable in. And it's an important factor if you are working in HR or in the legal department to consider where your business does business to see where it's enforceable, and if there's a jurisdiction in which you do business that they're more tricky to be enforced, you want to make sure that you're drafting or you're getting the agreement drafted in such a way that it's going to be enforceable where you want it to be enforceable. Okay, so I go to work for that big corporation. On my first day at work, most likely I'll be presented with a stack of documents I need to sign and also videos I need to watch and all that fun stuff. I'm excited to be there. It's a new day. I'm excited to have this career. One of the documents in my stack is going to be this arbitration agreement. Very likely I don't even bother to read it. I just kind of sign it and go on to the next item. But let's say I do read it. And I'm concerned about it, and I show it to the HR person or whomever is taking me through the process, and I say, I don't really want to sign this. Do I have to? It's very likely that person will say, no, you don't have to, but if you want to continue your employment with us, you do need to. If you choose not to sign it, then we'll end your employment at this time. Well, under those circumstances, virtually everybody is going to sign it because, after all, who wants to be unemployed at that particular moment? After all, you accepted the job, you've already quit whatever other job you have, and nothing has happened at this place of employment that makes you think there's going to be any problems. Most likely, there never will be any problems. So let's say you go to work for this company, you work for them for 20 years, and then something happens. You're terminated or you're laid off, and you feel like it's because of some unlawful reason, so now you want to sue the employer. And so you file your lawsuit. Well, one of the first documents your former employer will likely file is a motion to compel arbitration. And the exhibit to that motion will be your signed arbitration agreement. And you might be saying, but I signed that 20 years ago. I don't even remember it. Okay, yeah, that's my signature. I kind of do remember it. But gosh, that's a million years ago. I had no idea that my employer was going to do this terrible thing to me 20 years later. Well, guess what? It doesn't really matter that you didn't know. Obviously, no one has a crystal ball. We don't know what the future holds. But when you sign this agreement, you agree to resolve any dispute through this mechanism. So guess what? This is the mechanism you're going to have. So pre-dispute arbitration agreements are the usual means that cases end up in arbitration. Going back to that Toro and Walmart example, in that initial contract, and on probably all the contracts that Toro has with Walmart, there's going to be an arbitration provision in it. Again, the parties hope that there will never be a dispute, but if there is, they will have already figured out what mechanism they're going to use to resolve the dispute. There is another way, though, that you can have an arbitration agreement, and that is post-dispute. So let's go back to my employment situation. But this time when I go to work for this company, there is no arbitration agreement. I worked there for 20 years. Something happens. I feel like I was a victim of some unlawful action. I file a lawsuit. The company who is my former employer doesn't have the ability to file a motion to compel arbitration because there is no arbitration agreement. But the employer can approach my attorney and say, hey, we think arbitration is in our interest and your interest. And if you want to, we can get out of this unfavorable situation and use arbitration. And my former employer might point out, look, through the testimony, we're going to have to present some facts that aren't going to make your client look too good. And that'll be part of the public record. Do you really want that out in the public domain? Especially since your client is going to want to seek other employment. Or, don't you want this case resolved quickly? If we take this through the court system, it might be, a year or more before it gets resolved. If we use arbitration, it's going to be faster. Or, arbitration litigation is more expensive. Your client probably doesn't have a lot of money these days since he's unemployed. Why don't we save some money for both sides by going through arbitration? So under those circumstances, if one party is able to convince the other party, then the two parties can enter into a post-dispute arbitration agreement. These are relatively rare because most parties see it as kind of a zero-sum game. If it's good for party A, it's probably bad for party B. So whoever recommends it, the other side is going to be kind of inherently suspicious of it. And so they're likely to say, no, thank you. I'm not interested in that. But it is a possibility. I would say most legal professionals see arbitration as favoring corporations over individuals. That's the common perception in the legal community. I don't necessarily agree with that perception, though. I think in the employment law area, actually, sometimes the reverse is actually more likely, that actually benefits the employee more than the employer. Let me give you an example of what I'm talking about. When we were talking in the first presentation, I talked about the fact that about a third of all lawsuits filed in federal court did get dismissed by the judge before it gets in front of the jury. I would say that number is perhaps even higher in employment discrimination cases. Lots of people file employment discrimination cases, but they're very, very difficult to prove, and it's pretty common for judges to dismiss the case. If the judge dismisses the case, the plaintiff is not going to get any money. And so that's a very realistic possibility when you file a lawsuit, that you're going to end up with squat. You will have gone through all of the stress, you will have spent some money, and you're going to end up with nothing to show for it. That's very demoralizing, obviously. But if you go into arbitration, there's still no guarantee that you'll get money, but you're going to spend less money, you're going to get a resolution quicker. And here's the thing about arbitration that is important to keep in mind. Arbitrators let me put it this way. Arbitrators don't want either party to feel like they have lost. A judge honestly doesn't care very much. But an arbitrator doesn't want there to be a loser, and let me explain why. Arbitrators are judges for hire. They want to be hired again. I mean, it's how they make their living. So if I am an arbitration judge in employment discrimination cases, and I usually seem to rule for the defendant, how many plaintiffs are going to want me to hear their case? Not very many, because they can pull up all of my decisions and they can say, oh, look, Groover sides with employers 70% of the time. That means that I'm probably going to lose if she hears my case. But if I tend to side with the former employees, well, then the employers are going to pull up my data and say, hey, look, Groover rules for employees 73% of the time. We don't want her. So the only types of arbitrators who are going to get much work are those that are pretty much in the middle. They rule pretty equally. And so that's kind of the sweet spot in terms of how you're going to get hired as an arbitrator. So you're constantly trying to think of ways as an arbitrator, and I'm making it sound like they're not acting ethically, and I don't want to suggest that, but there is some tendency on their part to be thinking, how can I resolve this case in a way that both parties end up with something? And this is sometimes referred to as kind of a colloquial term. It's called splitting the baby. It goes back to a story from the Christian Old Testament that involves Solomon, who was a wise king who was asked to decide a particular case. Anyway, his solution to the case was, we ought to split the baby in half. Not because he thought they ought to cut the baby in half, but because he knew that once that was said, the true mother would say, oh no, don't harm the baby, and that's how he would know who the true mother was, so he'd be able to give the baby to the true mother. Anyway, so splitting the baby isn't a good thing. We don't want a dead baby. We want an intact baby. And so arbitrators have a reputation for kind of saying, well, I'll give a little bit to the plaintiff and a little bit to the defendant. Well, you can see how, given the fact that so many cases are just completely lost by plaintiffs, filing an arbitration in an employment discrimination situation, it increases the chances of them getting something. Now, it probably also decreases the chances of them getting everything they want. But those are some factors that kind of play into the arbitration thing. But despite the fact that I think there's a pretty good argument that it could be beneficial for many employment discrimination plaintiffs, the reality is that relatively few of them will agree to post-dispute arbitration. Arbitration clauses are usually binding. They don't have to be, but there's a problem if you don't have them be binding. Of course, in this context, binding means that there's not going to be any appeal, and that whatever the arbitrator says is the final word in the matter. So if he rules against you, you're out of luck. That's just the deal. You can have a non-binding arbitration clause, meaning that you go through arbitration, but if you don't like the decision the arbitrator made, then you can take the matter to court. The problem with that is that almost always one party doesn't like the decision. I mean, even when the arbitrator really does try to split the baby, many times both parties are a little bit ticked off, and they might both think, well, I should have gotten more money, or I should be required to pay less. And so when it's non-binding, many times it doesn't actually work to do the things that we talked about it doing. For example, if you end up going through arbitration and then going to court, it's not going to be faster, it's not going to be cheaper, it's not going to be any less certain. You're going to still create the precedent. There is no confidentiality, and if anything, it's more adversarial because you go through 2 trials. So that's kind of the worst of all case scenarios. So you definitely don't want that. Med-Arb is another choice. This is not very common, but you might see it. This is a combination of mediation and arbitration. So what happens is that you go through mediation and then you have an arbitration. One flavor of this is that the mediator starts out as that neutral party who's just helping, and then he or she changes into the arbitrator. Sometimes you have 2 different people perform those roles. And again, this is just, one, there's an infinite number of flavors you can have this, but these are some that you'll see sometimes. A summary judgment trial is when and both sides can participate in this, or one side can do it on its own, is that it has some people who are hired basically to pretend to be jurors, and these jurors hear just maybe opening statements or maybe the key 1 or 2 witnesses, and then the jurors tell both sides, if both sides are participating, just one side if one side's participating, how they would rule and why they would rule the way they did. And based upon that, that could let both sides know, I'm going to lose, or there's a real chance I'm going to lose. And it might give a bit of a reality shot to one of the sides. Of course, it can, if the case doesn't settle, that information can be used to make both sides prepare the case in a different way. Obviously, if it's done by only one party, it's not so much ADR, it's just a trial preparation technique. Then you can have a mini trial, which is very similar to a summary jury trial. The difference is that there isn't a jury in this situation, that you have someone neutral like an arbitrator who offers an opinion. This is like non-binding arbitration, but because it doesn't have quite as many of the bells and whistles, it is going to be a less expensive technique. And then you can have a private trial. It's basically like arbitration, but for whatever reason, another name is being selected for the term. Okay, so here are some things that you might choose to do, especially in an expensive case or a case that you're very concerned about and its effect upon your business. You might have a mock trial, and this is again similar to what we talked about here with the summary jury trial or mini trial. This is when, as a preparation technique, you hire people to pretend to be a jury, and you listen to what they think about the case. Sometimes you can be very surprised by their reaction. Obviously, you're going to want to hire people to be in your jury panel that are going to match the demographics of the likely jury that you will seat in the case. And so you might think that grandma, who's one of your witnesses, comes across as charming and sweet, but you discover that the jurors thought she was a manipulative person or something along those lines. And sometimes they can pick up on dynamics that you weren't aware of, or maybe they see dynamics that or maybe aren't there. But in any event, that's helpful for you to know. It can help you both adjust your settlement posture and also adjust your trial technique, what you want to emphasize, what you don't want to emphasize. Another technique, which is similar, is not to have a separate trial where you have a trial before the real trial, but to actually have a panel that sit in the courtroom and who act as a jury. And so after each day, obviously you can't talk to the people on the real jury at the conclusion of testimony every day, but when you have the shadow jury, the shadow jurors will come back to your office, and then you'll get to ask them, well, what did you like about today's testimony? What did you not like about today's testimony? Did you believe this witness? If you didn't believe this witness, why didn't you? There are problems with a shadow jury. For one thing, the main jury is going to wonder who these people are, and they may well kind of figure out who they are, and they aren't probably going to like the fact that one side hired a shadow jury. So if they can figure out who did it, that's not necessarily going to be a very impressive thing. They're going to think that's kind of manipulative. Another thing is that the shadow jury knows which side they work for, so they are oftentimes, kind of trying to ingratiate themselves, or they're really not being neutral in the process. And so sometimes the data you get from a shadow jury isn't as good as you might like. And obviously, it's a fairly expensive thing to do. And when you're in trial, you don't have extra time. So meeting with a shadow jury, is going to eat up time that you could be preparing other aspects of your case. I hope this presentation about alternative dispute resolution has been helpful. Thank you for your attention and have a wonderful day. If you have any questions, please come to my office hours or ask me about them during class.